Hello and a very warm welcome to you. This is your number one legal talk show, The Courthouse, and I like to call it our Law Class 101 because we get to learn the law together, not just with legal jargons, but we learn the law in plain, simple, and entertaining language. And this week promises to be very, very interesting. Some things that we hitherto took for granted are going to be made plain, and it's more like we are unveiling some things to you this week. I am Etohan Olomu-Agbodo. We'll be right back after this break. You're welcome back. This is the Courthouse, and this week I told you we have something interesting, something that we were taking for granted. We have the issue of the next of kin. Ordinarily, we just write the names of our spouses, the names of our children as our next of kin. But what is the position of the law? Who should be your next of kin? And what is the view of the law? How does the law see it? And also the issue of change of name. How should your name be changed? And joint ownership of property by husband and wife. These are issues we're going to be looking at this week. I guess you are going to find this very, very insightful. I know you're going to find it very insightful indeed. And we're joined by a seasoned legal practitioner. He'll be joining us online, and he is none other than NIYI ODUNSI. He's a legal practitioner based in Nigeria, and he is the best person to put us through this topic because he is very, very knowledgeable. He's a legal expert and a tutor for our Law Class 101. So you're welcome to the Courthouse, sir.
Welcome. Thank you very much for having me tonight. Great pleasure to be here.
We are looking at this issue of next of kin. Who, first of all, who is a next of kin? What is the term next of kin all about?
Okay, well, that's a very good one. Like you said in your introduction, there's been a lot of misconception really about this term next of kin. Now, legally, your next of kin is just your closest living relative, which for a married person will be a spouse and then children. For an unmarried person, then you'll be talking about the parents or the siblings. Now, also, the next of kin would be someone that can be called in cases of emergencies. For example, someone is involved in an accident, car accident. Who do we call? Someone is in a coma. They have to perform an operation. They need some form of consent. Who do we call? That's the next of kin. So basically, legally, that's who you would refer to as a next of kin. That's just what it is.
Okay, so basically your next of kin is, in simple terms, like your emergency contact.
The emergency contact, yes, but not just emergency contact. It has to be your, if you are being strictly legal, it's your closest living relative. So if you don't have any, if both parents are dead, no siblings, then maybe the next of kin can be a friend or something like that.
Okay, that's quite interesting. So there you have it. Your next of kin is legally your closest living relative. For a married person, who should be your closest living relative? Is it your husband or your wife or your children? Who is your closest living relative? And then the issue of change of names. Recently, we've been seeing that just publishing in newspapers and swearing to an affidavit is not enough to validly or legally change your name. So can you enlighten us, throw more light on this, sir?
Well, until recently, what most people thought was the right thing to do would be to go have an affidavit of change of name and then just publish it. This was the case until the recent case of PDP, the Bayelsa State governorship election, when the case went up to the Supreme Court, PDP versus Bioba Rakuma, yes.
Bioba Rakuma.
The Supreme Court, Yes, the Supreme Court explained that the process is not just by having a sworn affidavit and then publishing it in the papers. The first and most important thing is that let's assume someone has an SSC certificate and there was an error, or even let's say he got his name then in that certificate is something that he no longer wants to bear for whatever reason or the other, maybe even as a result of marriage. What has to happen is not just to go swear to an affidavit and then do a newspaper publication. What has to happen is that there has to be what is called a deed poll prepared. And with this deed poll, you have to go to Nigerian Civil Registry, and then they have to gazette this change. It is after this change has been gazetted that you now approach whatever institution issued the certificate to rectify the name there, to change the name, as it were. So it's not just swearing to an affidavit and doing a newspaper publication, as was thought by most people, that actually the law has been there. It's not a new thing. People were just acting out of ignorance. But with the Supreme Court judgment now, it's become clear how to go about the procedure.
Okay, sir. You just mentioned the fact that the case of Bioba, the name is quite a tongue twister, PDP versus
Yeah.
Biobarakuma, and that the Supreme
Yes.
Court made known the fact that just swearing to an affidavit and publishing a change of name in the newspaper would no longer suffice. And you even mentioned that the law has been existing. How come a lot of us didn't know about that? And now we are being told that your certificate bearing your old name, you have to go, after the deed poll, you go to the institution that gave you that issued a certificate for them to effect the change. How come we didn't know about this, and how easy is this process really for those trying to change their names?
Well, why we didn't know about it, or why most people didn't know about it, it's the law sometimes has to be tested. People assume and then find themselves to have been wrong. I mean, look at the case we're talking about. The consequences for the gentleman was most grievous, and he couldn't even deny the facts because they were obvious. Custom is not the law. The fact that something is being done by everybody does not mean that that is the right thing. We have to learn as Nigerians, to study the law, know exactly what is expected, and follow the right procedure. You'd be surprised how many institutions, even government institutions, before now would readily accept the affidavit of change of name and the newspaper publication. They would just accept it. Nobody knew that it was much more than that. And, it's something that we all have to learn to follow the law and do things the right way. Now, as to how difficult it is not really difficult because the Nigerian Civil Registry we talk about, it also registers deaths and births. You are aware of people having a birth certificate. You are aware of people having a death certificate. And with respect to a death certificate, let me also mention that there's a difference between a certificate of cause of death and a proper death certificate. A certificate of cause of death is one issued by a medical personnel, the doctor that certified the body as dead. Now, that is different from a death certificate because many times when death certificates are required, you find people coming up with the certificate of cause of death. You must obtain the certificate of cause of death and then go to the Nigerian Civil Registry. You find many of them at the local government offices. You go to these places and then they issue a proper certificate of death. So it's the same thing here. You do your affidavit / deed poll, and then you take it to these offices. That is where they will now follow the laid down procedure. So it's not difficult at all to do the right thing. The only thing is, well, with the Nigerian factor, because remember, this thing must be gazetted before it can even have the force of law. So that would depend on, whatever state you're in, whatever office you're in, whoever you're dealing with, as to how soon you can get that done. But it's not something that is difficult to do at all. It's just procedure. It's normal procedure.
Okay. Thank you so much. You just talked about the fact that it's not difficult to do, really, but the fact that this case is setting a precedent now, don't you think it would open a floodgate of more litigations and more cancellation of probably appointments, and people that hitherto thought they were in a particular position, they'll be ousted just because of the revelation that this... Okay, go ahead.
Well,
Sir.
it will depend. It will depend on a lot of factors. I can imagine what would happen. This is normal. In places where people would rather think about taking advantage of procedural rules than looking at the very facts of the case and doing the justice of the case. We do hope when these matters get to the Supreme Court, my hope is that they will look at equity, fairness in taking decisions. They would rather look at the substance and then give judgments that will, be fair to all parties concerned. But I guarantee you are going to have a lot of those kind of cases. They're going to start coming up now. This particular case was terrible. I mean, it was terrible. The names were not consistent. And it was obvious that the gentleman involved had no defense whatsoever. So it would depend on the circumstances of each case to see whether or not the law would say, look, you made a mistake, ignorance of the law is not an excuse, therefore, well, you have to be removed from that position, or you've told a lie. It will depend on the circumstances, really. But I can assure you we're going to have lots of those cases.
Okay, that's quite an interesting one. Like you said, ignorance of the law is not an excuse. We've been listening to a very distinguished legal practitioner, NIYI ODUNSI, who's been talking about some of these issues relating to next of kin and the fact that if you change your name, you have to do it properly. But I want to take a listen to our report on this issue, and we'll be right back. We'll still have him waiting for us. Don't go anywhere.
It's been popular knowledge for a while now that when one needs to effect a change of name, they would need to depose to an affidavit of change of name and a newspaper publication. However, the recent Supreme Court judgment in the case of PDP and others versus Bio Barakuma, Degi Eremio and others has clearly stated otherwise. Generally, an individual has the right to change his or her name at any time for different reasons, especially marriage, divorce, child adoption, among others. However, certain steps need to be fulfilled for the change of name to be valid in law. The first step in processing a change of name in Nigeria is to swear to an affidavit under oath in any high court close to the applicant stating the reasons for the change of name. The next step is to announce publicly the change of name by publishing the new name in at least one recognized national newspaper. Further, for official certificates bearing the old name of the applicant, a deed poll needs to be sworn to in the Supreme Court of Nigeria, deposing to facts necessitating the change and that the change will be effected by the relevant authority that issued the certificate. Finally, the new name of the individual is to be printed in Nigeria Official Gazette. This process involves sending an application to the Documentation Department of Publication, Civil Registry, requesting the advertisement of the change of name. It is noteworthy that if any correction, including name, is intended to be made on any certificate, the proper authority to make the same is the one that issued it. Hence, one still has to recourse to the issuing authority with most of the documents listed above to validly effect a change of name.
You're welcome back. Well, if you just joined us, this is the courthouse, and this week we've been having a very interesting time speaking with a senior legal practitioner, NIYI ODUNSI, and he's been giving us some insights into the issue of next of kin and the the issues pertaining to change of names. And he's still here standing by, and he's going to be fielding questions on the status of ownership of property by a married man and a married woman. These are people that are married. They call them Mr. and Mrs. Is there anything like Mr. and Mrs. under the law? What is the status of Mr. and Mrs.? Can they own property jointly? And if they own property under that joint name of Mr. and Mrs., how does the law look at it? So we are asking you those questions now, sir. It's quite interesting that a lot of people have come to know that the fact that you are married doesn't mean that you are no longer an individual, and we are getting to find out more interesting write-ups on that issue. So what's your take on that, and what's the position of the law as it pertains to the status of joint ownership of property of a married man and woman, and the concept of Mr. and Mrs.?
Mrs. Yes, thank you very much. That's also an interesting one. Recent developments have also shown that people have been doing things in error. In the past, it was possible to buy a property and say Mr. and Mrs. A.B. Brown, and then they would go to the lands registry and obtain governor's consent, and they accepted it at that time. Even some certificates of occupancy could have Mr. and Mrs. So and so. But recently, it's also been discovered that this has been a big mistake, an error, as it were, that's been perpetuated. But now, if people had really looked at it in the past, they would have found out that there is no juristic person called Mr. and Mrs. A and B Brown. A juristic person is a person recognized by law, and you have either a natural person or you have a corporate person, as it were. Now, when you have two people who, just by virtue of writing down Mr. and Mrs., think they have now become a juristic person, that is unknown to the law. So what you must have now is you have two distinct individuals. When we're talking about the property, both of them can own it. It's not that the husband and wife can't own property. They can, but their names have to be stated individually. Mr. X.Y. Brown, Mrs. A.B. Brown. Both of them can have shares in that property. Both of them are juristic persons. They are different people according to the law, in the eyes of the law. Now, you look at this because it has to do with things like, let's look at inheritance. Somebody writes a will, and on the property you have Mr. and Mrs. A.B. Brown. Now, the fellow, let's say it's the husband, in his will, he tries to give that property to, maybe he has a second wife, to his second wife. Now, what happens? Can he really give that property to his second wife? Who owns the property? These are some of the challenges, because he doesn't own all the property. He only owns maybe half of it, maybe 3/4 of it, maybe whatever. But he does not own everything. He can only give away in his will that part that is his own. But when we had Mr. and Mrs. Brown owning the property, it became a big problem, because now there's an argument. What part does this fellow own? What part does that fellow own? And then, are they even a juristic person according to law? So you find out that in the lands registry, like Lagos State, for example, they started turning down this kind of deeds that bear the names Mr. and Mrs. this, because we must know who is involved. But in a case where, for example, it is written Mrs. Ruth Brown and Mr. David Brown, then that is in order. But in this part of the world, what happens is, most of the time when you say Mr. and Mrs., you leave out the name of the wife. So you say Mr. and Mrs. David Brown. Now there's Mrs. Elizabeth Brown, but she's not mentioned in that document. So the tendency is to say it belongs to the man, not to the woman, whereas both of them actually own the property. So these days, to avoid any kind of confusion, they want to know exactly who Mr. Brown is and who Mrs. Brown is. And as long as both names appear on the document, then there's no ambiguity. If Mr. Brown dies, Mr. Brown can only give half of half of that property to whoever he wants to give it to. Mrs. Brown owns half of it, so he cannot give that half belonging to Mrs. Brown to somebody else.
Yeah, that's quite interesting, sir. But let me just ask this question. Is it not, the woman is supposed to be submissive, and that position where they have to go Mr., Mrs. initially, is it that it's just basically human nature, an issue of morality that's made a lot of documents to have only the name of the man expressly stated, and now are we trying to make the woman more independent? I'm just trying to be a bit funny on this one.
The truth of the matter is, unfortunately, historically, in most parts of the world, women were treated as chattels. I'll give you a strange example. You're talking about in ancient Greece and Rome. Now, if someone's wife committed adultery, you could not sanction her morally, but you could claim damages from the correspondence, as it were, the man that committed adultery with her. You could now claim damages from him because what he has done is to trespass on your property. I hope you get what I'm saying.
Yes.
It was more to go to court to claim damages. You could go only on a commercial note to say, look, you've trespassed on my property because you slept with my wife. So you can see that women were treated as chattels over the years. But thank God, in recent times, the world is beginning to realize how important women are and to give women their rightful place, where men and women are, even before God, equal. A man is not supposed to be more important, as it were, than a woman in the eyes of God. Even in Nigeria, but for the Ukeje case at the Supreme Court, among the Southeast,
yes,
a woman couldn't inherit anything from her property, and that went on for years until the case got to the Supreme Court, Ukeje versus Ukeje, and the Supreme Court said such a custom is barbaric. And so, because of things like that, women now women could always own properties in Nigeria, but in some other places and some religions, women can't even own property. If a woman has a wealthy father and the wealthy father gives his property to the daughter, it's the husband's property, as it were, because a woman could not own property. So that's what, unfortunately, became the custom, where a man and a woman, owning property, most of the time is taken to belong to the man. In those days also, talking about divorce, in divorce courts, even if a woman gave her husband money to build a property, to build a house, if they go to court and the woman says, well, I gave him money to build it, unless the woman can produce receipts to show that, okay, I bought 10 blocks, I bought, some windows, the law would say, the property belongs to the man. But thank God that also is changing now. It's irrelevant whether the man built the house or not. The judges will look at the circumstances of the case, and in most cases, award the matrimonial home to the wife. That's a given in developed countries, but it's also beginning to happen in Nigeria now. The fact that the woman didn't contribute any money to building the property doesn't mean she won't get it if she claims it during divorce. For example, if she was a housewife taking care of the children and the man was working, and then the man is the one that put money down to buy the house, depending on the circumstances, the man now commits adultery. There are 3 children that this woman at home has brought up. The man decides he's going off. He now says the woman should pack out of the house. If the woman goes to court and asks for ancillary relief, settlement of properties, it's almost certain that the courts will give the house to the wife. You see, so things are really changing, and that's for the better.
Okay, that was quite interesting. It's quite important for us to note these things, these changes, and not to take them for granted. It's good that the law is being made plain here, and we thank you for your contributions, sir. And just before we go, what are your final words, and what can you say NBA should do, NBA, the International Bar Association as well, what should they do more to enlighten people better about their rights and these basic misconceptions that we've been living with?
Well, it's education, education, education. People have to be educated to, start doing the right thing. A lot of people are ignorant, and thank God, even during this lockdown, there's been a lot of education. There's been a lot of seminars, conferences, webcasts, trying to educate people as to so many things going on. And thank God for technology. It's a lot easier to educate people, but you're talking about people who have access to the internet for that. But when it comes to the community, when it comes to people who can't even read or write, it's a duty, I think, of the communal leaders, the obas, the chiefs. These are the people that have to now be educated themselves so that they can begin to educate people. This is what the government is supposed to get involved with: educating people, organizing town meetings, and letting people know exactly what has changed and the new laws and the new ways of looking at things that are coming up. If not, there's still going to be a lot of challenges dealing with these things. And like we saw from the PDP and Bayelsa State Governor, the consequences can be really terrible.
Thank you very much, sir.
Thank you, Johan. Thank you so much.
Yes, sir.
Thank you.
Well, that's much we can take this week on the courthouse. It was quite interesting. Things that we were taking for granted. We're taking the issue of change of name for granted, but it could be very, very costly. Know the law, know your rights, know these basic things for yourself and apply them. Not just to know them, you have to apply them as well. It's Olomu-Agbodo. We'd like you to download our app, Lover Plus. We'd also like you to visit our website on www.loverplus.tv and to send comments or the numbers I'll be showing on your screen. We want to hear from you. You can use our hashtag the courthouse, hashtag LoveWordPlus to send your comments. And if you have questions, keep those questions coming in. We have legal experts ready to answer your questions freely. Remember, don't just get mad. Go get a lawyer. Bye for now.